Hi folks, welcome to RJA Impact. Today we're going to be talking about week 13 in the Holmes Theranos trial. Now you can search this channel for previous week's updates and also for a more detailed video on the background to Theranos and Holmes' journey to the point at which this trial commenced. Please don't forget to like this video and subscribe to the channel, and also hit the notification button so that you don't miss out on any future videos. As a reminder, Elizabeth Holmes is in court accused of multiple instances of fraud against doctors, patients and investors in connection with her role as CEO of Theranos, and this is week 13 of that trial.
What do you think's going on here?
Well, this is what happens when you work to change things, and first they think you're crazy, then they fight you, and then all of a sudden you change the world.
Well, with Roger Parloff last Friday, we had the conclusion of the prosecution witnesses. There were a couple of discussions in court after that and before the jury came back after a break. Now, the defence sought to exclude the testimony of Erin Tompkins. If you remember, she was the patient that had had the false positive HIV result, and primarily because there was no doctor called to provide the jury with experts' opinions on what was a complex test. The prosecution in turn were seeking to deny evidence submitted by the defence in respect of events that happened after the period that they are prosecuting. These are things like patents submitted and applications, etc. Now, I'm not going to provide a background section this week, as I'm going to provide a bit more detail on Holmes' own testimony and a bit more than I normally do for witnesses. I would normally do a draft for these weekly updates and then work out how to cut it in half and then try to cut it in half again. This time I'm leaving in most of the detail relating to Holmes' testimony, and I think that is appropriate. Courtroom update. Just before we get into the trial itself, there was a briefing by Judge De Villa last Friday. De Villa told the court that the trial is unlikely to finish by December the 6th, and the judge addressed the lawyers on both sides while the jury was out of the courtroom. "I don't think any of you, I hope none of you, are being strategic in terms of timing," he said. "None of you want the jury deliberating the case in the third week of December," he also said. Well, actually only a couple of days later, this week, De Villa changed the expected end of the trial and gave a definitive date of December the 17th, which is what he's now predicting to be the final date. Well, to me at least, that is the third week in December. And so to the trial. We'll wrap up Friday's initial starter defence witnesses before getting to the main course. Trent Middleton. The first defence witness was Trent Middleton, who worked for a company called Williams & Connolly and was questioned by defence attorney Catherine Tretz. He was called as he'd been retained by the defence to review thousands of legal and other documents, including patent applications. After the earlier courtroom discussions, it had been agreed that patent applications during the period of indictments could be admitted. There were quite a few diverse type documents that were quickly gone through, for example, Theranos cash flows and balance sheet, the 275 total separate investments in Theranos, the Theranos testing menus and pricings, doctors' testing records, e.g. for one, Dr. Asin, he had had 233 customers with a total of around 2,000 tests ordered. There were quite a few other doctors' records submitted, and here the defence are trying to show that the specific tests that the prosecution had brought up as being incorrect were just in some way isolated and perhaps not as significant as the prosecution had maintained. The prosecution took their turn and did focus on the 275 investments. Middleton had used the word entities when talking about the investors, and the prosecution pointed out that there were people behind these entities, and perhaps he used the word entity to avoid the inference that individuals had lost money. Middleton confirmed that the defence had suggested that he used the word entity. Fabrizio Bonanni. He took a role on the board of Theranos in spring 2016 after being approached by Holmes. He'd spent decades in the biotech industry, including Amgen and Baxter International, and he was brought in after the departure of Balwani. He was there to discuss the successor of the Edison machines, the Minilab analyzer. Now really he was there to explain how the tech worked well and plays into the defence claims that the company was a failure, not a fraud. However, under cross-examination, he had to say that even after switching to the Minilab, Theranos were not capable of doing over 200 tests, nor was being used by the military. He said that he did not know what Holmes had told investors. Elizabeth Holmes. Yes, that's correct. After over 100 hours of cross-examination of witnesses, many more hours of courtroom wranglings, and 12 long weeks, Elizabeth A. Holmes took the stand. Let's address the very first question you're going to ask. What voice would she use? And yes, she is using the famous baritone. We had a quick delve into detail when she said that in 2009 the company had had a breakthrough and the company went on to develop 300 tests, but the proprietary devices themselves could only do 12 tests. The defence then started to do a build-up of Holmes' own background, and we heard she was born in DC, she went to Stanford. Originally she worked there on microfluidics. She was a researcher at the Genome Institute in Singapore, working on SARS amongst other things. She'd had the idea for Theranos at the Genome Institute. And the original idea was a pill with sensors that would go through the body, sending information wirelessly to an outside server. The pill would then release a drug depending on the results. She filed this as a patent, although she didn't have a prototype at that time, and this was in her sophomore year while at Stanford. She explained how she then spent the monies saved by her parents for her to attend college on the startup idea. Originally, the company was called Real-Time Cures and later changed to Theranos. Dr. Channing Robertson became the first board member of the company. Holmes structured the company around three things: assays, hardware and software, and the pill morphed into the idea of the company's analyzer. Now, Holmes' whole demeanour at this point is one of some slight nervousness, but generally she's coming across as the confident person, similar to the recordings and videos that we've all seen. She'd taken off her mask for the first time in the trial. Well, after a prototype, she started fundraising and reached out to Don Lucas, who's a famous Silicon Valley investor. Lucas was very thorough. He spoke with everyone in the company and wanted to see the financials. Pete Thomas, another investor, became involved at this time. He also looked closely at the company. Yet another investor, David Lester, spoke with someone at Pfizer about their relationship at that time. It was much later on that Pfizer dropped the relationship with Theranos and before the period of the alleged crimes. Holmes had signed a deal with Pfizer in 2006 and spoke about a demonstration they did in Switzerland with Novartis. This was a success by all accounts. "We nailed this one. You did an incredible job in making this happen. This is the Theranos way," Holmes had sent out in an email to Theranos employees. Back at Theranos, the employees were all over the data coming back from the demo. John Howard wrote to Holmes, "What a gratifying morning this has been, our first live demo." He even sent a picture of the war room back at Theranos with their experts. "Here is a picture of the ABCS guys hovering focused on being sure nothing went wrong," he said. And so we are back at the trial on Monday. Well, it shouldn't be a surprise to anyone that the courtroom is now back at capacity, together with the overflow room, and the queues that formed meant that many people wouldn't be able to get in. The ones that did apparently started queuing at 4 AM or 5 AM or even earlier. John Carreyrou himself turned up between 4 and 5 AM. Holmes herself arrived at around 8 AM. After a delay in starting the trial on Monday, Holmes took the stand again. She was asked about the tech development that Theranos went through after the Novartis demonstration. She said that she knew there were some issues with their devices and during 2007 worked on them until by the end of the year they had their Theranos 3.0 device. Holmes talked about miniaturizing blood handling robot arms, which are similar in function to the one here. She said, "We thought that this was a really big idea. These robots used in traditional labs had not been miniaturized in a device that could be put into the point of care. The benefits were twofold, eliminating human error and creating a programmable device that could do more than one test." A key milestone followed in 2008, which was demonstrated through an email by Ian Gibbons. Gibbons was the chief scientist at Theranos at the time. That email had conclusions including performance design goals have been demonstrated and it's now in clinical evaluation at several sites. In 2008-2009, Theranos had tried to get involved in research projects to further their product development. She tried to get involved with the DoD and an organisation called Tatric, both of which came to nothing. They did partner with Stanford on a study for sepsis, and this was very favourable, and conclusions from a report on that study which were read out include the following. Very clear patterns of disease progression, remission and effects of therapies are apparent. Good correlations with outcomes are apparent. The samples will provide an excellent database for prognostic algorithm development and clinical assay validation. Assay results have been precise. Now after this, the machines did go out to a number of places for clinical studies, and an internal presentation shows the following. Studies with Novartis, GSK, MBG, Merck, Mayo, Stanford University, Pfizer, Celgene, Novartis and AstraZeneca. All of this is well before the alleged crimes. The defence are somewhat making the point that Holmes' claims about validation by major pharmaceutical companies could refer to these early studies. The judge is also making clear that the exhibits are being admitted for the purpose of understanding the state of mind of the defendant rather than the truth of the exhibits. The defence then went through a number of these studies that showed things like Theranos tech performed well, requests to use data from the studies in research projects, good correlation between Theranos and other analyzers. Anyway, you get the point. Holmes did say that by 2010, Theranos focused on putting its blood testing tech into retail stores rather than working with pharmaceutical companies. Now you'll remember the Schering-Plough relationship that was testified about by Constance Cullen, where Cullen said that she was unimpressed and she was quite damning of Holmes and Theranos. Well, we heard quite a different angle on that saga when Holmes said that Schering-Plough hadn't informed her of any concerns with their tech. And about a year after Cullen was assigned to the Theranos evaluation, Schering-Plough had merged with a company called Merck & Co. Now the latter's scientists wanted to pursue a partnership with Theranos. Cullen had had a phone call with one of Holmes' assistants and offered to serve as a reference for Theranos. All in all, it was awesome, I think, the assistant wrote to Holmes. Key to Holmes' state of mind defence is that in early 2010, Holmes was told by her staff that their blood testing device, the Series 4, could run any blood test. Ian Gibbons, Theranos chief scientist who committed suicide in 2013, wrote that the new tech would be able to run potentially 15 tests from a single blood sample. I understood that the Series 4 could do any blood test, Holmes said. On Tuesday morning, people were arriving at 4 a.m. to ensure a seat inside the courtroom. While waiting, there is inevitably a bit of banter amongst the people in the queue. One enterprising artist, Danielle Baskin, actually had created a Holmes-themed merchandise impromptu store. You can see her pitch here. So we got to court. Holmes was shown an email in court from a colleague with some of the work done with major pharmaceutical companies as part of its process to validate their machines, and we had comments read out with the following: Bristol Myers Squibb & Co, Home Run, Merck & Co, great correlation, GlaxoSmithKline plc, eliminate the need for a lab. These were indeed examples of great feedback. The defence then addressed Shane Webber, who wrote the damning Pfizer report on Theranos. Downey for the defence asked whether after 2009 Webber was involved. He wasn't, Holmes said. We got to 2010 and saw the progression of the development again through to the Theranos 4 device. At this point I'm deliberately going to skip over some of the detail. Essentially there were lots of emails about the assay tests that could be done and progress on these by the various teams in Theranos, most of which go into a lot of detail about the tests done, but they were all showing progress done of typically tens of tests in each section. Just one email to exemplify the progress was from Ian Gibbons again to Holmes. I think we have demonstrated capabilities fully equivalent to lab methods in areas where we have done assay development, he wrote. We also heard that the company at this time had developed its own manufacturing capabilities. 100 plus people at one time were actually working to produce the devices. Now at this point in the company's history, Holmes testified that they then switched to wanting to put their Theranos devices into retail pharmacies. The idea, said Holmes, was to do it right there on the spot, sending data to mobile phones. Which pharmacies, she was asked. All of them, she replied with a laugh. 2 of them, Walgreens and Safeway as we already know, went further and entered into serious conversations. Well, it couldn't be avoided forever, so we got to the point at which the alleged forged documents from Pfizer and Schering-Plough were addressed. Holmes admitted that she had added the logos of the companies to the top of the Theranos reports before sending them to Walgreens. She said, "This work was done in partnership with those companies and I was trying to convey that." She wasn't trying to give a false impression, but she said that after hearing the testimony at this trial, "I wish I had done it differently." In this respect, we also heard that at one point Holmes had sent the report to Pfizer, which does back up the assertion that she wasn't trying to hide anything. Why did they not put the Theranos devices into pharmacies at Walgreens, she was asked. It was Walgreens' idea, she said, so the plan changed. She said that Theranos lawyers had disagreed with the interpretation of FDA and CMS regulatory oversight in the stores, but that they had agreed to do what Walgreens wanted and shifted to the centralized lab model. When questioned on the issues that were happening when they eventually got the Walgreens pharmacy project up and running, she said, "It's never smooth, and there are always challenges in a lab setting." We hit another of the key prosecution tenets when we heard about why Theranos started using third-party devices. It was simply because the volume of samples was too much for its own proprietary devices. Now, this is counter to the prosecution allegations that it was because their own technology had failed, and the company then lied about how its tests were done. Now, in this whole testimony on the Walgreens rollout, Holmes has said that Daniel Young was responsible for the whole project. There are many emails from Holmes in around 2012 to Young citing things like test the system over and over and over again to make sure that it was working properly. There is a certain attributing of blame going on here to Young by the defence. An August 2013 email from Young to Holmes. The current launch list covers over 200 tests in both blood and urine samples. The collection of these reportables covers over 97% of test frequencies for these two matrices. Without the technical interpretation of this email, it is actually showing that Holmes was being given information to rely on what the prosecution are alleging that Holmes fabricated to investors. Now, on the volumes coming from the Walgreens rollout, we were trying to figure out this issue, Holmes said, of huge numbers of samples coming in at the same time. So we came up with the idea of adapting third-party machines to use the small Theranos sample. This made a lot more sense, she testified, because you could process all of those samples at the same time. Now, they didn't tell anyone because it was Theranos intellectual property, and Holmes said that, based on advice from counsel, this was an invention we understood from our counsel that we had to protect as a trade secret. If we disclosed that information, we would lose our trade secret protection. They did tell the FDA, however, but in 2015 the FDA had declared that their proprietary device was uncleared, therefore banning their use. A switch of tack when the testimony of Sarika Gangakidkar was discussed. Now, to remind you, she had testified that she had resigned over concerns for the technology. However, Holmes countered this and said that Gangakidkar told her that she was stressed and had health issues. An email from HR which mentioned similar issues relating to stress and family life in another employee appeared to back up that assertion. We heard about the big names board that Holmes had assembled. Each member was paid $150,000 per year, and Kissinger himself another $500,000 as a consultant. Holmes told us about the information she showed to the board, including plans to protect its intellectual property. One of the angsty investors was talked about, Alan Eisenman. Holmes said that she was surprised he had invested again because we had a lot of frustrations around these interactions. We couldn't give him any more information, she said. About the information provided to various investors, Theranos had a standard presentation that dated back to the early years and was sent to anyone, including investors. About the financials, Balwani was responsible for making Theranos financial projections. We heard about payment to a marketing firm, primarily to allow Theranos to strengthen its own brand and identity. One of the issues with Walgreens, for example, was exemplified in the statement, but we knew Walgreens could easily replace us. We heard about two projects that Theranos got involved in with the military, one to address burns victims with the intention of providing better information on how to counter infection. The second was to see how the devices could work in 120-degree heat, for example in Africa. Holmes said that some changes were made to their machines, but they held up well. The touch screen still had some problems. An earlier exchange had involved the advertising that forms part of the indictment. She said that she did not personally research all of the statements in the marketing materials. Now, in a dig at the Wall Street Journal, she said that at one point they were working with Joseph Rago from the Wall Street Journal. Holmes said that she and others reviewed Rago's article before it was published. Now, according to one commentator, this is a major no-no in journalism. And that was it from Holmes and Kevin Downey for the defence this week. The judge wished everyone happy holidays and gave them some strict warnings. He reminded them not to talk about the case. He said, "I realise that means strong fellowship with families, getting together with families and friends," he said. "You might be asked, 'Gee, what have you been up to?' Walk away as best you can," he said. With the pandemic and flu season, he said, "Please be safe and make good choices," adding, "We want to see you again on Monday next." And as a final little flourish, he commended the gallery for not typing so loudly. As my initial takeaway so far, most but not all of the allegations that the prosecution have raised in their arguments have been addressed in one way or another. There is still a glaring hole, however. We have heard nothing about the abuse allegations against Sunny Balwani. Will these be addressed next week? We await with anticipation. As usual, we'll do a rundown of the week in the bare essentials. However, I'm going to take a departure from the norm here. I will include the first two defence witnesses, but not do a summary of Holmes' testimony. I think it's probably better not to do this piecemeal week by week, but to do a single overarching summary once she's finished her testimony. Please don't forget to like this video if you do, subscribe and hit the notification button so that you don't miss out on future trial updates and other videos when they're published. Week 13 in a nutshell. Trent Middleton. Trent was an employee of Williams & Connolly, and Trent had reviewed thousands of documents for the defence, and it was primarily called to introduce the various documents that the defence wanted to cite and bring into court. There were many diverse type documents introduced. Now, the prosecution focused on use of the word entities rather than the names of the individuals who'd lost monies. Fabrizio Bonanni. He was recruited by Holmes to join the board of Theranos. He was very experienced in the biotech industry and was a replacement for Balwani. He explained how the Theranos technology worked. Under cross-examination, he said that the devices were not capable of doing 200 tests and there were no contracts with the military. Well, that's it from me for the week. So that's it, and don't forget, this is the first time in this trial I can say, don't forget that these have been defence witnesses.